Hello everyone. Happy Friday. I have just been out to a strata building, a site visit, as I like to do sometimes. And this building brought me out to have a look at an area of common property that has been granted to a lot owner for their exclusive use to park their car. Now, this is something that many of you will be familiar with. An owner's corporation has the right to grant the use of part of its common property to a lot owner for a particular use, and it often happens where there is some space in the parking area for an additional car space that is given to an owner to use. It is done on terms that they must comply with and enshrined in the form of a bylaw. In this particular building, there was a bylaw in place, or is a bylaw in place, and it dates all the way back to the 1970s, but it is just not working. The space is actually too small for most vehicles to fit in comfortably and not infringe on other people's use of the common property. And the building wanted me to advise on whether the bylaw could be repealed. Now, they have sought the consent of the owners who have the benefit of the bylaw. They've sought their consent to the repeal, and those owners, quite predictably, I guess, understandably, have refused to consent. And that is a requirement. If you are going to repeal a common property rights bylaw, or what we used to call in New South Wales an exclusive use bylaw, you do need the consent of the owners who are enjoying the right under that bylaw. If those owners don't consent, yes, you can go to the tribunal, and that's what I was talking to this building about, but you need to prove to the tribunal that the consent has been unreasonably withheld. So you have to show that the owner is being unreasonable in withholding their consent. And the tribunal is going to take that application quite seriously and is going to look at all of the circumstances. Is the owner paying for their use of the common property under the bylaw? How long have they had the use of that property? Did they buy their unit with that right to use, for example, that parking space in place? So have they relied on that right? Have they paid extra for their unit because they have had that right under a bylaw? All of that's going to be relevant to the tribunal's consideration as to whether this bylaw should be repealed. Now, I have in the past been involved in cases where the tribunal has repealed a bylaw, and this was a really valuable one that I was involved in. It was one lot owner being able to use the rooftop, the common property rooftop. But in that case, I think they'd had that right for about 20 years from memory, but they had not paid anything for it. And there was some question about whether the bylaw had been properly resolved at a meeting. We looked back into the history, looking at all of the minutes. And in that case, the tribunal did repeal that bylaw. So that lot owner lost a very valuable right. And that does happen. But what you need to look at in New South Wales is Section 149 of our Strata Schemes Management Act, which sets out what an owner's corporation needs to do if it is repealing an common property rights or exclusive use bylaw. And that's the section that says the owners with the benefit of the right have to consent, and if they unreasonably withhold their consent, then the tribunal can order that the bylaw be repealed. So some Friday facts there for you. Hope that is helpful, and I will catch you here another time for some more strata news, strata knowledge. Have a great weekend, guys.